Ms. R. Evans.
Good morning, you may be seated. Calling the cases of People versus David Charles Kemmer, file numbers 11-4277-FH and 12-4251-FH. Would counsel identify for the record, please?
Your Honor, Austin R. Rowe making a limited appearance for Mr. Kemmer for purposes of arraignment.
Mr. Kemmer, would you please raise your right hand to be sworn, sir?
Yes.
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Could you tell us your name?
David Charles Kemmer.
Mr. Kemmer, in each one of these two files, you appear here today for two purposes, the same two purposes in each file. First, to show cause why you should not be held in civil contempt of court for allegedly failing to pay your court-ordered money as ordered in each one of the two files. And second, to show cause why you should not be held in criminal contempt of court for allegedly failing to appear here in court in each of these two files on July 13 as ordered, July 13 of 2021. And the reason you were ordered to appear in court on July 13 in each one of these two files was to show cause why you should not be held in civil contempt of court in each file for allegedly failing to pay the court-ordered monies as ordered. Do you understand those things, sir?
Yes, sir, I do.
If you're found guilty of criminal contempt of court, the criminal contempt of court, then the maximum penalty the court could impose in each file would be 93 days in the county jail, and the minimum sentence would be discretionary with the court. Do you understand those things?
Yes, Your Honor.
You also do have a right to have a lawyer represent you in the criminal contempt of court matters. And if you're financially unable to hire a lawyer, then the court will appoint a lawyer for you. Do you understand those things?
Yes, Your Honor, I do.
And thus far, Attorney Austin Rowe is here to represent you at least through today's initial arraignment on the criminal contempt of court matter and in each file, and on the civil contempt of court matter in each file. Do you understand those things?
Yes, Your Honor, I do.
We'll go ahead with the civil contempt of court matters in each file first before progressing to the criminal contempt of court arraignments. Mr. Kemmer, is it true that in each one of these two files that the last time you made a payment towards your court-ordered money in either file was back in 2019?
Yes, that sounds about right.
And is it true, sir, that you were supposed to be making payments each and every month and had been ordered to make payments each and every month in both of these two files?
Yes, Your Honor.
And is it true, sir, that for a year and a half or the last year and a half to 2 years that you have not made any payments whatsoever towards your court-ordered monies in either of these two files?
Yes, Your Honor, it is.
And is it true, sir, that through the exercise of due diligence and trying that you could have paid something towards your court-ordered monies in each of these two files in the last year and a half, even though you might not have been able to make the full payments each and every month on time, every time, sir?
Yes, I probably could have came up with something, yes.
All right, I do find that you are in civil contempt of court in each one of these two files, and that through the exercise of due diligence and trying, that you could have paid substantially more towards the court-ordered monies in each of these two files than you have paid in the last year and a half, which has been zero. You may purge yourself of civil contempt of court in each file by spending 30 days in the Clare County Jail with credit for time spent in jail. Were you arrested yesterday or today, Mr. Kemmer?
I don't know when they arrested me, but it was last night that they came, so.
It was when, sir?
It was last night that they came. I don't know if it was midnight yet or not. I'm not sure.
All right, I'll give you credit for 1 day spent in jail towards the 30 days in each one of these two files. The two 30-day periods will run concurrently to one another. They'll run at the same time. And through your lawyer, Mr. Rowe has met in chambers with me ahead of time and indicated that once you are released from jail, that you'll be able to pay a total of $75 in each of the two files?
Yes.
Yes. So for $150 a month or 75?
75.
75 a month,
All right.
both files combined.
You may purge yourself of civil contempt of court in each of these two files by paying $37.50 per month towards the court-ordered monies in each file for a total of $75 per month. The first payment would be due 30 days after your release from jail by 12 noon on that day, and then each additional $37.50 payment would be due in each file for a total of $75 per month within 30 days thereafter. So every 30 days, you would have to pay a total of $75 towards the court-ordered monies. Now, if you make each of those payments in full, on time, every time, then at the end of 1 year, after you've made 12 consecutive payments, you would be purged of the civil contempt of court, and you would not have to return to jail. If you fail to make any of those payments on time, in full, then it's the order of the court. You must report to the Clare County Jail by 12 noon on the date that the late payment was due to finish serving your 30 days in jail in each case. If that does come to pass, and you find yourself sitting in jail because you failed to comply with the court order, you still can be released from jail, but only after serving the 30 days, the balance of the 30 days in jail in each file, or upon payment in each file of $450 in each file for a total of $900. Do you understand the sentence or the order of the court, Mr. Kemmer?
I have a question about it, Your Honor.
Sure. Go ahead, sir.
So if I get out today on,
If you get out, I'm sorry, I don't mean to jump to conclusions and interrupt you, but if you get out of jail today, then 30 days from today or before, you must pay $75 total in the two files, $37.50 in each one of the two files. For a
right,
total
Your
of
Honor, but what I was wondering is if I spend the 30 days in jail because something happened and I couldn't pay, then am I supposed to pay $150 to the court to get out for the following month also, right? Or you're saying 30 days after I'm released?
What I'm saying is this: if you spend 30 days in jail you
Right.
will be purged of the civil contempt of court. If that does happen, then you'll be purged of the contempt of court. The debt will still remain. And once you get out of jail, you still will have to make these regular monthly payments. So it's not like the old cowboy movies where the judge says you can spend 10 days in jail or pay $10, and the guy says, well, I'll take the 10 days because I don't want to sit here for 10 days, but once that's over, I'll be free of the debt, and I will have paid my debt by spending time here.
I
That's not
understand.
the case here. If you spend 30 days in jail, you will be purged of the civil contempt of court, but you still will have to make the regular monthly payments and pay these two court-ordered debts off
I
in
understand.
each one of the two files. But I don't know if that answered your question or not, sir.
Yes,
Okay, thank you, sir. Do you understand the order of the court then?
the order of the court is, no jail time today, but I gotta pay it within inside of 30 days of being released, right?
Yes, sir, among other things. There were other nuances and details, but
Right,
That's part of
the $450, yeah.
okay, thank you, sir. That will be the order of the court. Because of the way we handled the civil contempt of court matter, I'm going to dismiss the criminal contempt of court charge without prejudice in each one of these two files. Thank you, Mr. Rowe, for being here. Thank you, Mr. Kemmer. Good luck to you, sir.
Thank you.
You're welcome. Calling the case of People versus James J. Bailey, file 20-6335-FH. Would counsel identify for the record, please?
Good afternoon, Your Honor. Chief Assistant Prosecuting Attorney Alicia Schwartz appearing on behalf of the people.
Your Honor, Austin R. Rowe appearing on behalf of Mr. Bailey.
This case is scheduled for a status conference today. It's scheduled for a jury trial to start in 2 days on Wednesday, August 4, 2021. Did you want to proceed by way of entry of a plea today, Mr. Rowe? Or did you want to proceed in some other fashion? Or just go to trial in 2 days? Or did you want to confer with Ms. Schwartz first?
Your Honor, I guess I'd like to do two things. One thing, confer with Ms. Schwartz, but also, Your Honor, I was given short notice of this hearing today. I tried to contact my client, who I usually have to contact through a third person. And so I asked that third person to tell him to call me, and I've not received a call from Mr. Bailey yet. So I don't expect him to appear in court today.
Okay, thank you. So as matters currently stand, you would expect to proceed to trial on Wednesday?
That's my expectation at this moment, yes.
Okay, thank you. And do you have anything you wanted to add, Ms. Schwartz?
I know, Your Honor. I did want to note for the record that we did receive today defense's proposed exhibit list, witness list, and defendant's proposed jury instructions this morning via mail. So,
Thank you, ma'am.
Your Honor, it was also emailed to the prosecutor's office on the same date that it was emailed to the court.
Okay,
July 28th, 2021.
thank you, ma'am. Very well, then apparently the proposed jury instructions have been provided to the court and to opposing counsel, although in the case of the defense a little bit late because they were supposed to be provided 1 week prior to the date of trial. But do you have any objections to the proposed jury instructions and proposed verdict form from the prosecution, Mr. Rowe.
I have no objections, Your Honor.
And Ms. Schwartz, do you have any objection to the proposed verdict form and the proposed jury instructions from the defense?
It appears to be identical to mine, so no.
Okay, thank you, ma'am. Very well, then the Bailey case will proceed to trial on the morning of Wednesday, August 4, 2021. Thank you for being here. Thank you, Ms. Schwartz. Calling the case of People versus William, and in the Bailey case, the bond status will be continued. Calling the case of People versus William Nemitz, file 20-6411-FH. Would counsel identify for the record, please?
Good afternoon, Your Honor. Mark Webb on behalf of the people.
Carl Levy on behalf of William Nemitz. Your Honor, I would specifically waive Mr. Nemitz's appearances at this hearing. I was advised of the time of this hearing, and it was about 10:30 this morning, and I did not have time to arrange for Mr. Nemitz to be able to attend either in person or via Zoom.
Thank you, Ms. Hovey, and thanks for appearing here on short notice. Any objection to that, Mr. Webb?
No, Your Honor.
Very well, then we'll proceed with the hearing. The people have filed a motion to adjourn the jury trial. The jury trial is scheduled to commence on Wednesday, August 4, 2021 at 9 a.m. Although the court less than 5 minutes ago it dealt with another case, People versus James J. Bailey, file 20-6335-FH, that is scheduled to go to trial on that same day, and which is an older criminal case. They both are criminal cases, so neither has priority automatically over the other. And in each case, it's the court's understanding in the Bailey case and the Nemitz case that each defendant is currently has posted bond and is not incarcerated. Do you oppose the people's motion to adjourn the jury trial?
I do, Your Honor. Your Honor, I appreciate that Mr. Bailey's jury trial may actually go, and by operation of that, we may be adjourned anyways, but if not, Judge, we are prepared to go on Wednesday, and the prosecution's request to adjourn is based on that they failed to issue their subpoenas, which, Judge, is on them, it's not on my client, and that they failed to secure a domestic violence expert. Judge, their request or their knowledge of knowing they needed a domestic violence expert goes all the way back to the point or the exact day that Ms. Schwartz signed the complaint on this case, which was June 2nd of 2020. Again, Judge, they've had plenty of time to prepare, and I'm just asking, Judge, that we be allowed to sit second and wait to see if Mr. Bailey goes to trial, and if not, that Mr. Nemitz be able to have his jury trial and have this matter resolved once and for all.
Thank you, ma'am. And the court has handled this motion thus far a little bit backwards.
I was just getting ready to point that out, Your Honor.
Because it's the people's motion to adjourn, and I've heard the defense argument opposing that motion first, although in fairness, the reason I inquired was of defense counsel was if the defendant was not opposing the motion, then maybe we didn't have much to talk about. However, please feel free to proceed, Mr.
Judge, I'll mainly rely on the statements I made in my motion to adjourn the jury trial. At this point, I would think it's moot if the court's going to do the Bailey trial. And even though Your Honor stated that you didn't think either case took precedence on which order to go in, it's my understanding that older cases would take precedence over newer cases. And it's my understanding that Bailey is the older case.
I believe you're right, at least in terms of older, in terms of filing, because Bailey's case file number is 20-6335, and Nemitz's filing date per filing number is 20-6411. So in terms of when they were filed in court, even if not on date by date of the alleged offense, the Bailey case is the older case. There are other factors the court would consider as well as, for example, if one was a murder case or a truly high profile or high stakes felony, carrying a much greater penalty potentially than the other, and things of that nature. But these two cases are relatively of a par. The Bailey plate case is at least slightly older. The Bailey case, as of now, is scheduled to proceed on Wednesday, August 4th. And while I can understand Ms. Hovey's position that, well, at the very least, let's everybody on both files show up on Wednesday, August 4th. And on the off chance that Bailey were to enter a last minute plea, then we could proceed with the Nemitz trial. The people are averse to proceeding in that fashion, and regardless of the merits of some of the arguments Ms. Hovey has made, whether they have merit or don't have merit, at this point, the court views this being a moot point because I think it's unfair both to the defense and to the prosecution to less than 48 hours before the trial to have everything up in the air and to say show up on Wednesday, August 4th at 9 a.m. for the trial. And you'll find out at that time, if not before, whether the Nemitz case is going to go to trial or not. Accordingly, the court will grant the people's motion to adjourn the Nemitz trial, and that trial will be adjourned without date at this point, but we'll schedule it as quickly as we can.
Judge, if I may then, I would renew the ongoing motion to set aside the no contact order. The victim has appeared before this court no less than 3 times and requested the no contact order be lifted. She's jumped through all the hoops of the prosecutor's office all the way back to December or January, where she requested that the no contact order be removed. And Your Honor, at the final pretrial, which I'm sorry, off the top of my head, I don't have the exact date. I'm sorry, July 13th. Ms. Schwartz indicated that she couldn't agree to have the no contact order set aside because she needed to keep the victim in line in regard to trial. Your Honor, she has not reached out to the victim, has not had contact with the victim, and the victim would once again, and I would on behalf of my client request that the no contact order be set aside because again, we're holding this family hostage, which has been hostage for 14 months, waiting for this to be resolved.
Thank you, ma'am. And Mr. Webb.
Judge, we would object to that request. And I'd like to clarify, we haven't been holding anybody hostage. I would say that COVID-19 was holding everything up, not our office, not the defense's office. So there's other things going on here besides the normal course of how the courts usually work.
Thank you, sir. Well, from the court's perspective, apparently, defense counsel is correct that it's been 14 months that there's been a no contact order in place. The last time we were in court on July 13, the court was, among a myriad of other factors, in denying the motion to lift the no contact order. The court took into account that we were scheduled to go to trial in approximately 3 weeks at that time. At this point in time, we don't know how long it will be before this case actually does proceed to trial. However, I'm going to deny the motion, and if there's a big delay between today and the date of the rescheduled jury trial, the defense is free to renew their motion. And thank you all for being here. The bond status will be continued.
Judge, if I may interject, can I be put on to your next motion day for that? Because Judge, I don't care whether that trial is scheduled yet this month. I'm going to request that no contact order be lifted again. And I don't anticipate that the prosecutor's office is going to advance their progress on this file in any manner between now and then.
All right, we'll schedule we'll schedule this motion to be reheard at 11 a.m. on Tuesday, September 7, 2021. The bond status will be continued between now and then. And of course, the court is not going to approach the rehearing of the motion in a vacuum. And the court will consider all of the other factors it already has dealt with at least twice as of today. But if feel free to re-advance those arguments if you want, Ms. Hovey, and also please feel free to bring to the court's attention anything else that changes between now and September 7th as well. Thank you, ma'am.
Judge, I have one more thing before
Sure.
we adjourn.
Mr. Webb.
I originally, once I got this case, I emailed Attorney Hovey, I think a week ago Monday, to let her know what the status was. And that if she would be agreeable to maybe adjourn to sometime in September. I never got a response. That's why I ended up filing a motion. And I'm pretty sure I filed that motion last Wednesday. Unbeknownst to me, one of my staff took it upon herself to walk that motion over to Ms. Hovey's office to give it to her as a courtesy. She didn't do that at anybody else's direction in our office. She came back, my staff came back all very upset. It's my understanding that Ms. Hovey got angry with her, swore at her, called Ms. Schwartz and myself names. And I just want to let her know it's totally unacceptable and I'm not gonna put up with it. And I want to remind her that the professional rules of conduct, rule 6.5 states, a lawyer shall, not may or can or whenever they feel like it or get mad, shall treat with courtesy and respect all persons involved in the legal process. And I'll just leave it at that.
Judge, I want the record to be very clear on this matter. I was engaged in communication with another attorney in my office when his staff came into my office. His staff interrupted my conversation. I accepted the papers, I ignored it and moved on, and she wanted to engage in a happy little conversation that I did not want to engage in. I told her that I was not pleased with this motion, that the fact that they wait 14 months and not get their experts and they don't send out their witnesses, and now she's gonna bubbly dance into my office like there's no big deal, that she could go back and tell them I was not accepting that. So Judge, unless you're present, don't try and establish that you were there, because I have 5 witnesses in my office that would be more than happy, Judge, to be across the street here in about a minute to testify as exactly how that conversation went down.
Well, thank you, ma'am. And as a point of personal privilege, certainly you have, in the court's view, a right to respond to the matter that Mr. Webb raised, but there's nothing before the court that needs to be addressed at this time. Nobody is asking me to take any action. So thank you all for being here.
Thank you.
For being
Thank you. All right.